Okay, coming to the next question, how once the perm is approved, how long is the perm valid and how long they have to file an I-140?
So the perm is valid for 6 months. So within that 6 months, you have to file the I-140. If you don't, if you file beyond the 6 months, then simply the I-140 gets denied, even if you try to file it. But of course, there are exceptions to that, which is basically if you have previously filed the labor cert already, and they already have a copy of it, because you've maybe filed it and it got denied, so you're refiling it. In that instance, number one, you will not have the original perm, which is fine. And second thing is that you don't have to adhere to that 180 days deadline. So that's an exception. Or also, like we have done recently, downgrading from EB2 to EB3. You don't require the original perm because they already have it. You don't have to request the DOL for a duplicate. So that process, we don't have to encounter that process. It's a normal process, and we don't have to worry about the 6 months deadline for the downgrade also. So these are labor certs that were approved in 2009, 2010, 11. So obviously the 6 months is already over. So these are the two exceptions. Refiling or an amendment, you don't have to adhere to the 180 days certification rule.
Okay, got it. Okay, the next question. Can the perm be filed for a part-time employment unlike the full-time?
No, unlike a H1 where you can actually file for a part-time person by indicating the number of hours, a green card is a permanent position. It's for a full-time permanent position. So you cannot really file for a part-time position. So yes, it's unlike the non-immigrant visas for this, it has to be full-time and it has to be a permanent position.
Okay, got it. So another question, let's say an advertisement and perm, the advertisement is for EB2 category, like needs masters with few years of experience or bachelors with 5 years of experience. Can a perm be still filed as an EB3 even though the ad is given EB2 category?
So when you file the perm, you give certain requirements and you cannot change those requirements later on. So if you're saying the requirement is masters plus 2 or it's bachelor's plus 5 or whatever it is, you can't change that requirement. If you want to change the requirement, then you have to file a new labor cert, right? So, but what you're doing in the I-140 when you downgrade is you're not changing that requirement. The beneficiary still has to qualify based on the original requirements in the perm application. But yes, you can decide which category to file in. You can decide to file it in EB3 if you want. Because if you qualify for EB2, obviously you qualify for the lower level, which is EB3. But the reverse doesn't work. If you qualify for EB3, you will not qualify for EB2. So you don't have that choice. But you do have the choice of downgrading. And even though you overqualify, you can still ask for EB3. So that's what you're doing. You're not changing the qualifications in the perm, or you're not changing the qualifications in the job offer. It's the same.
Okay, can it be done this way, like, can they file two different petitions, one as EB2 and EB3, just to keep both?
Right. So I-140s you can keep. That's what we did in October. We filed a new I-140. There was a controversy about that, though, whether it can be done or not. But we filed a new I-140 and kept both the EB2 and as well as the EB3 numbers. We kept both applications. So tomorrow, if the EB2 becomes current, then they can cross-file using the EB2 I-140. So that was the whole purpose of doing that. Some people wanted to do amendments, so which is basically you're amending the existing I-140 to an EB3, in which case then the original I-140 is lost. But if you file a new one, then you're not amending, you're filing a new application. So both are, and you're using the same labor cert. There's no separate labor cert. You're using the same labor cert, but you're, just have two I-140s filed because you can choose which employment-based category you want to file in.
Yeah, got it. So recently, there's a premium fee increase, for a few of the applications. Is it also applicable to I-140?
Yeah, 2,500 is the fee now for the I-140 as well.
Okay. Do the applicant have to include, or it's optional to include the family members in PERM or I-140? If so, what are the consequences?
So in the labor cert, there is no option to include family members. They don't ask for that. That's not the purpose of it. The purpose is simply to look at the job, see if there's any qualified applicants, and if there isn't, then the DOL would certify that job is a green card can be filed for that person. So when you file the I-140, that's the immigrant petition. That's when you're actually filing the immigrant visa, and you're including your family members. You're letting them know whether they're in the US or if they're abroad, etc., etc. So that's done at the I-140 stage. But for example, if you're not married at the I-140 stage and after that you get married, you can still include family members. But if you were married but didn't include your spouse, then you might have to file an amendment in order to file a 485, for the missing family members.
The next question is, can the applicant leave the country if there is an emergency when the PERM is pending or when the I-140 is pending? If so, there are any consequences?
So focusing on the labor cert, there is no issue with leaving the country if the labor cert is filed. There's no issue even at the I-485 stage. But if you file a family-based application for 485, then you can leave the country even then, but you have to file for advance parole, get the approval, and then leave. If you are filing for 485 based on employment, then you can leave the country. There's no problem. You don't need to get an advance parole. You can leave and come back on your H1 or whatever visa you have, as long as you have a means of coming back. And for that, to answer your question, for the labor cert, no, there's no such requirement that you have to stay in the country once the labor cert is filed. You can leave.
How about 140? How about 140?
No requirement for I-140 also.
So, okay, it doesn't really matter even if they had to go for a bit. Okay, we have a question offline. It's little off the topic, not completely. So one of the viewers, he had filed for the 485 using the filing dates in the month of October. The dates were current then. I mean, the filing dates were. But then the dates moved back a year last month. So USCIS returned the application saying that, you are not in the filing dates, even though at the time of filing, he was in the filing dates. I mean, it was between Jan 2014 to Jan 2015. When the case received, they are current, but, USCIS returned it saying it was probably a mistake. So what can be done in this situation,
That's unfortunate because it seems like USCIS error. But even in a situation where USCIS has committed the error, if the visa numbers are ultimately not available when in order to refile, they won't accept it. So even though the error is on their part. So this is, I think, a really good case for district court because they will not accept it now, because they will just say that our hands are tied. Even though the error was from our side, we cannot accept the case because the visa bulletin, won't allow us to accept it. There's no exception which says that if USCIS makes an error and if the visa number is not available, you can accept a case. So in the law, when there's no such exception, the officer cannot make that exception. Maybe a judge can, but I don't think that case will be accepted if the visa numbers are not there.
Okay, we have a caller. Yeah, sorry to interrupt you. We have a caller. Let's take the caller and then we can continue on it. Hi, Sweta. Welcome.
Yeah, hi. Can I talk to Prashanthi?
Yeah, you are on the air. Please go ahead.
Okay, thank you. Prashanthi, this is Shweta and I'm calling from DC. I have a question related to one of my H1B. I'm currently working for an employer, and now that I got a new opportunity, so as it's work from home, I think I can manage the two jobs. So I was saying that we can file a concurrent employment. So now my question is, if in case I'm filing a concurrent employment which says like full-time opportunity as a no, and in the future I'm comfortable continuing the second opportunity which I choose, the concurrent filing, and I leave the opportunity with client A. Do you think like I should file an amendment again for the concurrent employment? How does it work?
So concurrent employment is when you choose to do two jobs. When you'll file the first H1
Yes.
as a normal H1, and the second H1 that you file,
Okay.
you will file it as a concurrent employment. So it's not an amendment. You're filing a new H1 as a concurrent filing. Just something to be careful when you're filing a concurrent H1 is that the number of hours that you're going to be working. I mean, it's possible to work two full-time jobs, 40 hours and 40 hours, 80 hours in a week. Some people do work 80 hours. So, but if it's beyond that, then it might not be believable. So just keep the hours to, a believable number. And so the second H1 will be filed as a concurrent H1. And then you can work for both employees at the same time.
I got it, Prashanthi. Like, the question is if in case I think like I'm not comfortable managing the both jobs. If it is not manageable for me in the future, I would, if in case, I think like, the concurrent filing client is a long-term opportunity. I feel like what if I leave the other job in the future, do I need to refile it again?
So if you want to leave your second job, H1 that you filed, you simply withdraw it. And you don't fall out of status because you have...
So
She's talking about if she wants to leave the first job and keep the concurrent filing.
Yeah, you can do that also. You can do either one. You could do either one. As long as you have one H1, you can stay in the country using that.
Yeah, since it was filed as a concurrent filing, is it necessary to amend it because she's
no, it's
now
not
only doing
necessary to
one
amend
job?
it. You can just it's a H1 and it's it's valid.
Okay, that shouldn't be a problem if I carry the same LCA which says like concurrent employment throughout the approved period, right?
That's fine. That's fine. It doesn't matter.
Yeah, that was my concern. Yeah, thank you so much.
You're welcome.
Yeah, Prashanthi, going back to the previous question again, in that situation where it was an USCIS error, what can be done? Can it be taken to court? A court case be filed because we know that this is once in a lifetime opportunity. We don't know if again dates would be even anywhere near. So, what advice do you give? Is it suggestible to file a petition in the court because it clearly is a USCIS error?
Yes, the only remedy would be to go to district court. So even there is a law. I mean, the law is there. So even the courts can only interpret the law, but even courts can't change the law. So I don't know to what extent it will be successful, but maybe they can interpret it in such a way that the original law was not meant to punish people, even though it was no fault of their own. Maybe it can be interpreted in that way, but otherwise, even courts cannot make the law. They can only interpret the law as it was meant to be. I think that you can always try to resend it back to USCIS and say that you made an error. It was, the visa number was available. Please accept this as, filed on time, as if it was filed on time, and see what happens. But most probably they won't accept it, but there's no harm in trying.
Okay, got it. Okay, we are towards the end of the show. Before we conclude the show, can you please provide some information on your law offices, practice areas, and your expertise, so the viewers would be seeking advice or consultation if needed?
My offices are in Midtown Manhattan, and I've been practicing immigration law since 1997. I do employment-based, family-based immigration law. So, my email address is prashanthi@reddyesq.com. You can call me at 212-354-1010, extension 107. We'll be happy to help with any questions that you have.
Okay. Again, before we end the show, if you have any questions or if you need legal consultation or a private consultation or help with any immigration petitions or family-based petitions, please reach out to Prashanthi for a private consultation at 212-354-1010 or prashanthi@reddyesq.com, and the website is www.reddyesq.com.